Order. Sir Jeremy Quinn to move the motion.
It's a pleasure to use this debate to highlight the ongoing issue of disabled young people's access to their child trust funds, to recognise the goodwill of the Minister and his department, but to demand changes that would solve issues for the courts, CTF providers, and above all, the disabled young people and their families. We have the means to secure easy access to funds that rightfully belong to these young people, funds that could prove invaluable, but which are denied to them by lack of information and processes that may well be well-meaning in intent, but are Kafkaesque and off-putting in delivery. It's a pleasure to propose the debate under your chairmanship, Ms Elliott. I'm delighted to see the Minister in his place, who I know is focused on this issue, and other honourable members who have taken a real interest in getting to a resolution on this issue. I would like to start by paying tribute to my constituent, Andrew Turner. Back in September 2020, Andrew found that his disabled son, Mikey, was locked out of his child trust fund. He simply wanted to buy an adapted bike with Mikey's money, and Mikey's life-limiting condition meant that time was of the essence. The child trust fund was Mikey's only financial asset. This should have been the start of a simple process in which a loving parent who looks after his disabled son can use that child's own funds to enhance the well-being of the child. Instead, Mr. Turner found that he and thousands of others were required to go to court when the account matured. Such is the complexity that Mr. Turner was, I'm sorry to say, independently advised that it would be easier and cheaper for him, and I hate to say this, but it would be easier and cheaper for him to wait until Mikey died, when a simpler process existed to reclaim the money. He was naturally deeply upset. He was also determined to do something about it, not just for Mikey, but others in the same predicament. I give way, the honourable gentleman.
And then for this here, and I did say to him beforehand, and I wanted to give Madam Chair the Northern Ireland perspective. In Northern Ireland, the responsibility for the management of the Child Trust Fund accounts for a child whom there is no person with parental responsibility. It's transferred to the shared foundation who deal with inquiries until the child turns 18. What I would suggest would be a good idea, and hopefully the right honourable gentleman would also agree. Does the right honourable member agree that responsibility should be given to extended relatives, such as grandparents, etc., to ensure that they are able to provide guidance within a familial setting in relation to finances? A really simple way of doing it. Let the grandparents or the extended family look after things.
Well, I'm grateful to my honourable friend, Member Sam Strangford, for his intervention. I will touch on the circumstance in Northern Ireland, but the fundamental point here, which I think unites many people in the Chamber today, is the desire to get easy access for parents, to ensure that they do not go through a court process incurring fees and going through bureaucracy, requiring support of GPs and social workers, to access what in many cases is an average of about £2,000. It's just too much bureaucracy and work when it's rightfully the asset of their child. I know there are many people in this area, in this chamber today, not just the honourable member, who've taken a close interest in this and have far more personal experience than me as the parents of children with disabilities, and they know that parents with the parents of children with disabilities have so much to do. Often this involves struggling to get what is rightfully theirs from government. This is one area in which Mr. Turner felt progress really could be made. The good news is that he found a groundswell of support from parents and charities. I'd like to thank in particular Contact for their support and Renaissance Legal for their tireless campaigning. There is support from Child Trust Fund providers and indeed, I believe, from the Minister. And yet 4 years on, we are still nowhere near where we need to be. I would like to set out the scale of the problem. I'll set out what I recognise the government has attempted to do to mitigate the issue, and lastly, what I believe it should do to go further and to largely resolve it for most families with disabled children. Let's be clear, this is not a new issue. It is very apparent and has been well rehearsed, and not only as a result of my constituents' brilliant campaigning. The Public Accounts Committee looked into the issue last year as part of their analysis of child trust funds. It highlighted a wider problem with CTFs as a whole. However, the PAC drew particular attention to access for young people lacking the mental capacity to manage their own savings. In these circumstances, a family or carer must gain legal authority to access funds that belong to the young person involved. To do so requires an application for a deputyship order to the Court of Protection in England and Wales. And in England and Wales, the Ministry of Justice estimates that between 63,000 and 126,000 young people may not have the mental capacity to access and manage their matured CTFs when they reach 18. All CTFs will mature between 2020 and 2029. There are therefore tens of thousands of young people who will be subjected to a prohibitively lengthy, costly and complex process to simply access what is rightfully theirs. Dealing with standalone CTF applications, there were just 70 court applications between September 2020 and May 2023, compared to around 27,000 accounts maturing over the same period. The Department, in its Treasury Minute, responding to the PAC, broadened the scope of applications to include not just standalone CTF applications, but other assets. However, even on that basis, between September 22 and March 23, the number of applications for 16 to 21-year-olds was still only 312. Whichever of the statistics one chooses to quote, thousands are missing out on what is rightfully theirs, because we are not informing them of their rights, and if we do, the process is too complex and too costly for all but a few. I know the Minister is a decent man. He put aside time to meet Mr Turner and me on this issue, and I know has instructed the Department to engage. I know he is keen to make it simpler for families, and he has ensured changes have been made. I acknowledge the MOJ last year moved some of the application online, waiving the fees and creating a toolkit for parents. This is to be welcomed, and I believe was introduced with excellent intent. However, the process still involves completing 12 forms, including the duplication of a number of forms, and 93 pages. This includes requiring time-pressured GPs or social workers to complete a 21-page mental capacity assessment, which not all are prepared to do. With all the pressures on the families of disabled young people and the associated cost of becoming a deputy, is it surprising that they do not prioritise accessing what is, on average, funds of around £2,000? But that's £2,000 which could and should be used to the benefit of the disabled child. I know the Minister and his team wish to help further, and there is means to do so readily at hand, already in use and absolutely capable of being advertised and delivered on, which could help deliver tens of millions of pounds. Actuarial analysis suggests up to 73 million into the hands of those that desperately need it. I would like to thank the chief executives of the two child trust funds, One Family and Foresters UK, for talking me through their proactive approach, which puts their customers first. These two funds account for over half of all CTFs. Very commendably, these providers recognise the problem and are applying a common sense and pragmatic approach to its resolution. This is, in effect, using the DWP appointee scheme, a tried and tested system to enable families to manage their child benefit income. It provides adequate protection and is the obvious solution to unlock the savings of disabled young people. Let us be clear, this is no free-for-all. The providers require evidence that the parent or guardian is a DWP appointee. They require identity checks and confirmation of the child's capacity. This process is only available to funds under £5,000, and complex cases may still have to go through the courts. But it has enabled the providers to meet the needs of hundreds of disabled children. But there is a problem. Despite it following a DWP process, despite the knowledge that were a DWP appointee to be acting fraudulently, there would be far more at stake than a modest child trust fund. This sensible route is frustratingly not officially sanctioned. The financial institutions are commendably going on risk to allow access to the funds. They know there are far more affected families out there, but as responsible, regulated entities, they do not believe they can advertise their willingness to help in this pragmatic way which combines existing safeguards with swift access. These two leading institutions and others with a similar proactive mindset are assisting some 900 families a year, a significant multiple of the court route. But thousands still remain who need support. I therefore have three requests of the Minister, which really would help resolve this issue. Would the Minister engage with DWP to extend the appointee scheme to officially include savings held in CTFs? Would he engage with the finance industry to formalise what is already a successful industry process, and in doing so enable them to advertise that route and enable families to take advantage of a simple scheme? And lastly, will the Minister help families to secure basic information about their CTF provider if the account has been lost? I am just reaching my conclusion, but I'll happily give way to my honourable friend.
Can I commend my honourable friend for his superb speech, and he's approached this debate in an extremely constructive fashion with a common sense, straightforward solution to the problem. Surely we don't need to reinvent the wheel. We just need to apply common sense. Child trust funds are a wonderful advantage to many young people, but the most vulnerable are missing out. And today he has outlined a way in which the government can address the biggest part of this problem.
I'm most grateful to my honourable friend, and he brings me brilliantly to my conclusion, which is that I agree with him. Movement on those three issues will prevent thousands of unnecessary court applications, reduce bureaucracy and cost for the parents of disabled youngsters, and above all put to work funds that could make a real difference to young people who could really do with that little extra help. I beg to move this motion.
The question is that this House has considered child trust fund access for people seeking to manage the finances of others. Call Sir Ed Davey.
Thank you, Mrs Elliott, and I'd like to pay tribute to the Honourable Member for Horsham for securing this debate, and I agree with everything he said, and I hope there can be cross-party agreement today that we need to move forward at long last. I'd also like to pay tribute to Andrew Turner, his family, and particularly his son Mikey, for the work they've done, but others, I'm sure Mr Turner would agree, have played a big role. Lawyers like Philip Warford, journalists like Jessica Hewson and Martin Lewis, financial service companies have shown leadership, Contact and other charities, the campaigning families, many of whom are here. Their voices have come together, and I'm just hoping that the Ministry of Justice is going to listen. Ms Elliott, I should declare an interest. I have a son whose name is John. He is 16. He has an undiagnosed neurological problem, which means he can't really walk by himself or talk, and he has serious learning disabilities. There's no doubt, I'm afraid, he will never be able to manage his own personal affairs, let alone financial affairs. And although my wife and I and many wonderful professionals work to give him as much independence as possible, there's no way when he comes to the age of 18 that he'll be able to get the money from his child trust fund. So I declare an interest, but I hope I have an insight into the issues that families face, the problems they have as carers, just looking after on a day-to-day basis. That can be quite enough without having to worry about lots of bureaucratic forms and having to go to the Court of Protection. Indeed, I've been involved in this debate for some time. I met Mr Turner in 2020, and I asked the then Prime Minister a question at PMQs on the 21st of October 2020. In his reply, the then Prime Minister said he would do whatever I can to help. Whatever I can to help. That was a promise nearly 4 years ago, and we are still here. So hopefully we can do a bit better today. In result, after that, I met the minister who was then doing the current minister's job, who's now the Secretary of State at the Ministry of Justice. I think I met him 3 times, and we discussed all the different options. We've seen all the work that's been put forward, the waivers, the so-called simplification of the forms, the digitalisation, all the attempts to try to make this work. Sometimes, particularly when the Ministry of Justice put forward the consultation on the small payment scheme, I supported it. I didn't think it was the best solution, but I was trying to be constructive. Let's go along with this. Let's try and make this work. But I'm afraid all these efforts have failed demonstratively by the statistics that the Honourable Gentleman Member for Horsham showed, and many others. So I'm afraid, to date, the Ministry of Justice has utterly failed to solve this problem. And so I just think we need to get action here. We can't wait much longer. The number of young people and their families, the amount of money just builds up time. It's not going to go away unless one minister, I'm sure it's the minister before us today, will actually grasp this properly. I personally initially set out believing that the DWP appointee scheme was the right one. It's one that families are aware of. It's worked in government. It's worked actually for funds much larger, because the amount of money you get through DLA or PIP for your loved one far outweighs the amount of money that the average child trust fund has. But apparently that's not possible, because there was some difference between flows of money from DWP and savings and capital. For life of me, I never quite understood that distinction, but maybe there's something in it. And I will come to what I think is behind the Ministry of Justice objections in a second. But in the spirit of wanting to be constructive, there are two solutions, it seems to me, that on the table. The one that the honourable gentleman talked about, which is this proposal for a new one-off order solution. So a family would still have to fill in a form, but it would be a one-pager. It would still have to go to the Court of Protection, but it would be a very, very simple process. And I think it's been well thought through by campaigners. Different fund managers have been involved. And I believe Mr. Turner has written to the Ministry of Justice before Christmas. Unfortunately, he received an email from an official in December 2023 which stated, "We are not able to consider any proposals for an alternative process for accessing child trust funds at this time," end quote. That's not good enough, Minister. People are working hard to come forward with practical solutions within the remit of the Ministry of Justice, and officials aren't even willing to see people who are trying to be constructive. This one-off order solution, I think, would work. I'd like to ask him, and he may not be able to answer me today, to get this one-off order solution working. Will it require primary legislation change, secondary legislation change, or would the Registrar of the Court of Protection simply have to change the administrative rules? It's probably as simple as that, and it would suddenly unlock this problem, both for child trust funds and junior ISAs. So that's one solution, which the MOJ would be in control of. There's another solution, which the honourable gentleman touched on, which is working through the financial service companies who've shown huge flexibility in this and taken risk upon themselves. That's not an MOJ responsibility. I think MOJ would have to go and talk to the Treasury, because I think government has landed this in the lap of the MOJ and said, you sort it out. But if the minister was to go to the Chancellor or the Treasury ministers and say, look, we want you to say this, and we're happy for you to say this, all a Treasury minister would probably have to say would be, we are relaxed about fund managers of child trust funds or junior ISAs taking this approach, taking the risk on themselves if anyone objects, but for them to both market, give information and promote the idea that the people with DWP appointed status can use these funds and transact them on behalf of their loved one. That would be what you might call a market solution, but it would, I think, the way government works, in my own insight into government, it requires the MOJ to give the green light to the Treasury to make that statement. Two really simple, zero-cost solutions to allow vulnerable people to get their own money, And I really urge the Minister, after 4 years of trying, let's just wake up and smell the coffee. Why might the MOJ be objecting to this? Let's put myself in his shoes, in the shoes of the officials, to work out what on earth is going on here. Well, the first thing may be the Mental Capacity Act 2005, the Court of Protection, and principles underlying those. When an official in a department has jurisdiction over an act of Parliament, they can get very jealous about how it's worked and not want to see any change. And I get that. We've been there. But protecting that principle behind the Act has to be challenged by democratically elected politicians to see and test it, or whether that principle is being taken too far. Because in law, there are other principles that apply. One is called proportionality. Proportionality, Minister. Reasonableness. And surely those principles apply here. We're talking about small amounts of money for very vulnerable people whose parents and carers ain't got the time to go to court. They may phone one person and say, look, can you help me? And then the other person at the financial service company or the court says, well, you know, it's a bit complicated. They just give up because their young person is in pain and needs medical help and needs to go to the hospital. That's the reality of the life.
I'm most grateful to Martin for on the specific point of proportionality. Would you not agree that, firstly, the financial providers are talking about sums below £5,000 and the average child trust fund here is about £2,000? And the second thing is the DWP appointee scheme. The DWP appointee scheme, Madam Chairman, is the amount of money going through that would be tens of thousands of pounds. Seen in relation to the child trust fund issue, the child trust fund issue is a tiny amount of money. So on the grounds of proportionality, I think the right honourable gentleman is making an extremely good case.
So I agree with that intervention, and I strongly agree with him. He might be interested to know that Principle 5, I'm told, I'm not an expert, Mrs. Elliott, but Principle 5 of the Mental Capacity Act talks about least restrictive means to achieve the best interests of the vulnerable adult. Now, you know, could the MCA apply itself to itself, please? Now, there's another reason, Mrs. Elliott, why I wonder whether the Ministry of Justice is sticking to the principle despite all the evidence, despite all the pressure. And maybe they want to get more people to go to the court protection so the judges there can help with the deputyships of these vulnerable adults as they go into they turn 18 and go beyond that. And, you know, one can have a discussion about whether or not more families should ultimately go to the Court of Protection. But when you read the guidelines of the Court of Protection, how it should operate, it really sees itself, and I think rightly, to be a court almost of last resort where there is a family dispute about money or more likely about how a person should be cared for, who should care for them, where should they live. And sometimes if there's a dispute in the family, you do need the court, and the Court of Protection is brilliant at that. Sometimes a vulnerable adult may have no loved one or family member, and then the Court of Protection obviously fills that vacuum, quite rightly. But if families can come to an agreement amongst themselves, you know, more often than not, it's going to be rather better than having to go to the Court of Protection. Now, make the Court of Protection available to them all, and advertise it, market it, and people you know, may want to think about that in due course. I and my wife, we're old parents. My son's 16, I'm 58, so I'm quite an old dad. And I worry about when I die, and my wife and I die, he's still going to be, doesn't have a degenerative condition, and he's going to live for quite a few years. So, you know, of course we're thinking in due course of going to the Court of Protection or some other means, or getting a family member, his sister or one of his cousins to be there for him. So the Court of Protection has good reasons to be there. No one's against it. But use it when it's needed. I mean, maybe the Ministry of Justice thinks it's got no court backlogs. There's loads of judges. They're just sitting there twiddling their thumbs. Give them more business. Come on. Take these precious off the system, please, by adopting something that's simple. I mean, I have to say, and I don't like saying this, Mrs. Elliott, there may be a reason why people in the judiciary and legal profession are keen to force people to go to the Court of Protection, even when it's disproportionate. Maybe it's vested interests. I hope that's not what we're dealing with. I really hope that is not what we're dealing with, because it's not acceptable. We're talking about people who are vulnerable, parents and carers who are stretched to their limits. And we're talking about small amounts of money. So can I just urge the Minister to listen to us, to go back to his department, go to his Secretary of State and say the officials need to be overruled on this. Some of the judiciary from the Court of Protection need to be overruled on this. We need to act proportionally. We need to act in the best interest of thousands of young people who should have access to their own money.
Thank you very much, Madam Chair, and very pleased to be able to speak in support of the debate brought by my right honourable friend, and it's a privilege and a pleasure to follow the right honourable gentleman who spoke so well. And, of course, Madam Chair, I entirely agree with what's been said. I had the pleasure of speaking a few weeks ago at a conference organised by the Share Foundation. Gavin Oldham is here with us today, and Andrew Turner spoke at this as well and laid out all the practical challenges that we've heard discussed. There was also a speech, very good speech, made by Ruth Kelly, the former Labour minister who had oversight of the Child Trust Fund policy when it was introduced. And it inspired me to recognise how often good Conservative policies are introduced by non-Conservative governments, because I have great respect for this, for the policy. We also discussed, I think another speaker discussed the real genesis of the Child Trust Fund, which was, of course, Tom Paine in the 70s and 80s, who wrote about an approach by which government simply gave families a lump of capital as a means of sustaining them and ensuring that they developed the habits of thrift and industry and self-reliance that we all need. And actually, Madam Chair, we might remember in the 1990s, the then Labour opposition were developing ideas around what they called asset-based welfare, which I think is a very good principle and one, and I wouldn't give it to Labour entirely. We all share these ideas.
Order. The sitting is suspended for 45 minutes for 4 divisions in the House. Please can all honourable members, please return swiftly or by 5:41 at the latest, where we will continue the debate. Thank you.
answers to that. You'll have to tell them.
So which one? Everybody come. Order, order. The sitting is resumed. The debate may now continue until 6:15. I call Danny Kruger to resume his speech.
Thank you very much. I shall resume rather than starting again, Madam Chair. I was saying that the origins of the Child Trust Fund, I think, have their roots in a very good British tradition of the principle of asset-based welfare. And in the 1990s, there was a tussle about an approach to public services. On the one hand, what we've come to call new public management, quite centralised, quite bureaucratic, quasi-market systems based on individual entitlements, comprehensive services, versus this approach of asset-based welfare, which was really about putting capital into families and supporting communities to develop their own collective responses to social challenges. And under the New Labour years, the new public management model won out with this great and noble exception of child trust funds, which is such a brilliant innovation. And I think such an important principle for the idea that people should be entrusted to manage wealth and to sustain their families directly. And I regret personally that in 2010, when the coalition government came in, the Child Trust Fund was abandoned. I was going to have a pop at the Liberal Democrats, who I'm sure were responsible for the scrapping of the Child Trust Fund. But let's just blame George Osborne, because we can all unite on that. But of course, the junior ISAs was established instead, which is a very good principle. Madam Chair, I wanted to echo the points that have been made very eloquently by right honourable members about the real injustice that families endure now with the fact that back in those days when the Child Trust Fund was created, not enough consideration was given to children without mental capacity to access and manage their own finances when they became adults. And I think something very wrong was done without anybody intending it, without this being properly thought through. And I won't repeat the points made by my right honourable friend, but I think we have a huge obligation now to right this injustice. It's also worth pointing out, not just that we have many tens of thousands of young people locked out of money which is rightfully theirs, and as we've heard, without the capacity, without the money or the incentive, frankly, to pursue a court of protection case to unlock it. We also have a significant negative incentive, disincentive to open a junior ISA for if parents have a disabled child, thinking about the long-term future of whether it would be possible to access that money. So we're inhibiting the principle of saving altogether. I think very good suggestions have been made by the right honourable member for Kingston and Surbiton and my right honourable friend from Horsham about a one-off order solution, absolutely echo the case made there, and also for this DWP appointee scheme. The fact that we do that for benefits which, as we've heard, often account for much greater sums of money than the Child Trust Fund means that we should extend that too. And I agree with the right honourable gentleman about relieving the pressure on the Court of Protection. So I'll just finish, Madam Chair, with the observation that the principle of child trust funds, such a good one, such an important principle in what should be the welfare model we have. And it's not just the injustice we have at the moment of the complexity of the system, the fact that there's so many dormant accounts, doesn't just apply for the families who know about it and want to have access to the money that belongs to their disabled children. There are many millions of young people who don't know that they have the right to this money, that this money is in fact rightfully theirs. And I understand there are around 6 million young people who, in theory, in fact in reality, have an account worth around £2,000 each that they're unaware of. And it's estimated that around 1 million of those young people will come from deprived circumstances. So what an enormous injustice it is that all that money is sitting there in government accounts that they're not able to access. And it's been described as an experience of malign neglect. So it won't be deliberate. Nobody is actively trying to prevent young people accessing the money that is rightfully theirs. But nevertheless, and as for reasons we've heard with respect to disabled children, young people, but also with respect to young people more widely, they're not being given access to the money that is rightfully theirs. And I echo the point made by campaigners, including Gavin Oldham from the Share Foundation, for a system of a default withdrawal policy, whereby young people who are registered with HMRC, the system knows their bank details. Around 60%, I understand, of young people with Child Trust Fund accounts that they've not yet accessed could simply be given the money. That should happen. There would need to be communications and an information campaign around that. But I think that is the right thing to do, and not least because it would stop this outrage of these companies charging 25% fee for the benefit of informing young people of the fact that they have this money. So this is, I think, the future model, Madam Chair. I think as a country we should be proud of the principle of child trust funds. I think there's a lot of people now thinking increasingly that we do need to develop approaches around asset-based welfare. I noticed David Willits, former colleague of ours, is proposing something similar, a capital sum granted to young people at coming of age. And I know that Gavin Oldham has suggested that inheritance tax receipts should be used to invest in child trust funds for the future. So I think this is an old idea whose time has come. And I hope we can fix these immediate problems we've got and then think more broadly about how to extend this model more widely. Thank you.
Thank you very much. It's a special pleasure to serve under your chairmanship this afternoon. And I pay tribute to the Right Honourable Member for Horsham for securing this debate on the behalf of his constituent Andrew Turner, and congratulate him on a fulsome speech which actually outlined very clearly the challenge that is actually before us today. I'd also like to comment on the speech from the Right Honourable Member for Kingston and Surbiton, and I'm grateful to him for sharing his personal experience with his son John, along with his experience of the system. I think he demonstrated a special empathy with other parents of children with very challenging disabilities. And, he offered solutions, and I remind the House of his most important statement, that people are just after their own money. He also spoke of the need for a simpler system, and that was repeated by the Honourable Member for Devizes. I've just found out how to pronounce that properly. I hope I did it justice this time. But he lamented the fact that we no longer have the Children's Trust Fund as set up by the Labour government. But he did try to blame the Right Honourable Member for Kingston and Surbiton. But it was the Right Honourable Member's colleague in the Treasury that did so, the same person, I'll advise the House, that axed the hospital that was planned to be built in my constituency of Stockton, where health inequalities have in fact widened ever since, and it's not even on the government's new list. And the Honourable Member for Devizes also confirmed that we do have a consensus in the room that we need action, and he said simply give them the money, which I think was a good way of for me to start, or at least mention at the beginning of my speech. Now, Andrew's fervent campaign to bring about change in this area stems from the challenges in his own family. They've come up against tremendous problems along the way, simply to get access for the money saved for their son, Mikey. Members have heard of the distress faced by Mikey's family and others, and to hear that deeply disturbing legal advice that Andrew received, that it would be easier and cheaper to wait until Mikey died because then a simpler process could be used. I can't find any words to describe the anguish in such circumstances. Now, Andrew has become an advocate for the many parents of children with disabilities who all too often come up against these barriers, and I pay tribute to him and charities like Contact for their hard work on this issue. I would also like to thank the other parent campaigners, Nazim Yazin, Claire Binney, Michelle Creed, Ramadeep Kaur, Rachel Dixon and John Roberts, and their son Joseph, for joining us here today. Now, the fund introduced in 2005 saw every child born in the UK between September 2002 and January 2011 receive up to £500 in government vouchers as an incentive for their parents and guardians to open a savings account for them, an initiative ditched by the coalition government in 2011 when the Junior ISA was created. Now, disabled children and those from low-income families received additional amounts to provide greater benefits in later life. Trust money was then locked away, with parents able to add more to the account each year until the child turned 18. But again, as we've heard, parents of children who lack the mental capacity to manage their finances themselves once they turn 18 are faced with making a deputyship application to the Court of Protection to access their Child Trust Fund or Junior ISA. The Ministry of Justice estimates that between 63,000 and 126,000 young people may fall into this category, yet the Court of Protection approved only 15 applications in 2021. Now, the Minister will be aware that Andrew wrote to the Lord Chancellor yesterday outlining the scale of the challenge. He highlights that since 2020, an estimated 31,488 disabled young people have been unable to access £72.4 million of their trust fund, Child Trust Fund and Junior ISA savings. Now, the Public Accounts Committee looked into this particular matter, and they highlighted reports of families finding the deputyship application process difficult, time-consuming and costly. Fees are waived if families are applying to access a Child Trust Fund, but there are other barriers. The committee heard examples of a 6-page GP letter being needed as part of the process. The Down Syndrome Association said in evidence that low awareness about banking safeguards among parents it supports is also a barrier to accessing their children's child trust funds. It explained the fee waiver does not apply if the young adult is still in education, and that many families believe they also need to pay for the services of a solicitor. Now, I recognise the government has considered measures it hoped would address the problem over the years and the problems that we come to discuss today. But the legislation and processes put in place to support individuals and their families should be much, much more accessible. What we need is closer working between the finance industry and government departments to find a workable solution to this ongoing problem, as it has the potential to significantly increase accessibility, helping many more families access savings locked in child trust funds and junior ISAs. Now, I agree with the statement from Una Summerson, Head of Policy and Public Affairs at Contact. She said, implementing a less restrictive approach is in the best interest of disabled young people. Disabled young people must be allowed to enjoy their savings like everybody else. Continuing to promote actions that fail to address this issue will simply perpetuate injustice. There is an opportunity to bring common sense into the debate and to commit to a new approach. I will.
Gentleman giving way. He's made a very powerful speech, and thank him for his kind comments. We're all hoping that the Minister will take the opportunity to make some changes today and to tell us all that they are going to look at this again and make changes. But will he agree with me that the next election and the next Parliament, if this government fails to make changes, it's vital that his party, working with others, makes these changes?
Yes, I'm grateful to the honourable member for his intervention, and yes, whichever government is in power have to make the changes necessary in order to make this much easier for people to access the funds. I don't know what the mechanism will be, but I think we can all say that the next government, perhaps of either colour, will in fact deliver on that particular promise. But the Minister, I'm sure, might get this sorted out before we have that general election, because I think today may have been the last day that the Prime Minister could have called the election, but we've still got a few hours to go. But bring that on. Now, the Government, in its consultation response, referred to clear evidence of the challenges in the current system, with the Court of Protection Property and Affairs application forms being too lengthy and complex, and the time taken between completing the application to the final order being made is too long and disproportionate for the sums involved. Instead of a wholesale change, however, the Government opted for incremental changes to the current court process. In 2023, the Ministry of Justice created a toolkit for parent carers on making financial decisions and implementing a new digital process for property and affairs deputy order applications rolled out last year. Set to speed up the process, users can complete some of their court forms electronically and digitally submit remaining paperwork. Sadly, Contact tell me that none of the Government's piecemeal changes have meaningfully simplified the court process or made it more accessible for families with no legal experience. The Government's strategy, sadly, is not working if their intended aim was really to have a process as accessible and possible. It simply hasn't been achieved. But I hope the Minister will outline the impacts of these changes have had on application processing times, address whether further digitisation of the Court of Protection processes is planned, and outline exactly how the Government is going to remove these blockages to the funds once and for all. Let them have their own money.
Thank you, Dennis. It's a pleasure to serve under your chairmanship today. First of all, I have to thank my right honourable friend, the member for Horsham, for securing this debate and continuing with the conversation that we've had for some time. I was pleased to meet with him and his constituent, Mr Turner, last May to discuss this issue, and I do welcome the ongoing debate we're having. Ms Ellis, I won't tiptoe down memory lane like colleagues have. I'm not sure what value revisiting the coalition government of 2010 onwards is particularly helpful to today's debate. What I do want to do, I think it's important, and I'm sorry if it's going to be dry, is it's important to actually lay out the legal framework that is there to protect vulnerable people. And I understand very clearly the actions of the vast majority of parents are well-intentioned and act with great honour and kindness looking after their child or their young adult. However, my job, of course, is also to protect vulnerable people from any form of abuse. And that weighs very heavily on any reforms that we take forward. And I appreciate people will disagree vehemently with me, but I do have to take into account that not every parent would act with the best of intentions when accessing these funds. We do know, Ms Elliott, that it's a well-established common law principle that an adult must attain proper legal authority to access or manage the finances or property of another adult. That includes, for the purpose of today's debate, a matured child trust fund of a young adult. And people are understandably unaware of this legal principle, and it may be surprising to parents and carers who've been very heavily involved in the decision-making for their young person prior to them turning 18. And I do want to iterate what steps we've already taken to try and improve the process, and also particularly to try and improve the awareness of what steps need to be taken as the young person goes over the age of 18. Of course.
I'm grateful for Mr. Gilway. Before he talks about the reforms that have been made, can I bring him back to the point of principle he just outlined at the beginning of his remarks? I don't think anyone disagrees that there's an important principle there, but there's equally a principle of proportionality, which I made in my speech. Could he address that point? Where does proportionality arise in his thinking about principles involved?
Well, I have to say to the right honourable event, I'm very happy to have an ongoing conversation. In fact, this is the first time we've actually discussed this face-to-face. We've not discussed this before since I took on this portfolio. But proportionality is a very valid point. But what is the level of risk the right honourable gentleman is willing to take will be very different from the level of risk I'm prepared to take or the government is prepared to take. The right honourable gentleman, anybody in this room, may be prepared to say 10, 20, 100, 1,000 young people could have their money accessed inappropriately. That's the proportionate risk they're willing to take. My view is I want to minimise that risk, and their proportionality is not an easily measured I'm not a lawyer, there may be a legal, and I look to my right honourable friend who I think is a lawyer. I look to my legal friend and say maybe there is a definition of proportionality, but the definition of proportionality on those who are making decisions against those who are asking for change may be very different. Now, I'm willing to see if we can bridge the gap, but my view is I want to ensure that we can improve access, but also ensure that protections remain in place so that those who may not have the best interests of the young adults in mind do not get access to the funds with total liberty.
I'm grateful for the Minister's answer. It was direct to the point, and he's given way again, which is very generous. When we're looking at this risk, though, we actually have evidence from the industry. The industry's looked at this case, and many of the firms and funders have said, we're prepared to take the risk on ourselves, even though the government isn't behind it. These firms, because the risk and the amount of money is so small, they've taken that risk on themselves. Isn't that not a lesson that the minister should dwell on? And if the MOJ isn't prepared to act on that, would he at least go and talk to his colleagues at the Treasury and see if they can make a statement about the way that the financial services could take on that risk and how the government would support that?
Certainly, I'm always happy to discuss with any provider, and certainly the provider I've spoken to, and no provider has beaten their path to my door saying that we think you've got it wrong and our risk assessment is right. Of course, any organisation is entitled to make their own risk assessment and take the consequences if they get it wrong. And that's there for their decision. My risk assessment is perhaps I'm being overcautious. I'm willing to be challenged on that, and I appreciate people have a different view. But I want to ensure that I take the least risk to vulnerable adults. But certainly my conversations, and I will talk briefly in the time left, about the work we've done with TISA to try and improve accessibility and knowledge. So if I may, Ms Elliott, I'll have to skip over now, given the time, about the legal framework of the Mental Capacity Act. I think everyone in the room is probably aware of the methodology of applying for the deputyship that gives people access or the ability to act on other people's behalf. So I won't go through that in any great depth. But we have heard that the court process was cumbersome, and that's why we did look to see how we can change that. We did consult as to what kind of different system we could put in place, but there actually was not a consistent view from the consultation on how we should reform the access to these funds. Because, in fact, when you go into the consultation, many people wanted to add safeguards into a new form of access that actually made the system even more cumbersome than the one we were trying to reform. So that was a difficulty. We didn't get actually a common view on what checks and balances needed to be in place. But we also did just talk to parents, we talked to charitable organisations, legal and finance sectors, groups representing the elderly, etc., etc. And what we did here is it was too complex, but the big message that came out was that people weren't really aware of what they had to do or when they had to do it. And so one of the things I think that my right honourable friend asked, I think it was his first ask, was would we extend appointeeships to cover child trust funds? We are working with the Department for Work and Pensions to extend the availability of information. And so without taking out at all, I'm more than willing to go back to the DWP and talk about whether their process is suitable for child trust funds. It's a very different process in terms of it is accessing regular payments rather than lump sums. So there is a different quantum at risk, but equally it would take primary legislation. So it is not, we double-check this today, it would take primary legislation to, if you like, copy or access the DWP-type processes. So it's not a quick fix, but it's certainly one that I'm more than happy to go back and have another look at. But in terms of what we've actually done, is I wanted to ensure that we've been trying to streamline the process. Can we take the paper out? Can we use more digital processes? And what we've seen is that the time has been reduced from 24 weeks to 12 weeks currently. And we'll continue to liaise with the President of the Court of Protection to monitor performance to see what more can be done. Now, one of the key issues is that people often don't know what they have to do until the child turns 18, and then they are locked out. So what we are looking to do, and we've done first two things, and apologise if this sounds a little disjointed, but I sat down with TISA, the major provider of these child trust funds, and we have agreed that they will write out, as part of their normal maturity mailing, they will include in that mailing advice and information about how to actually access and use the court of protection to get the relevant legal powers in place. So that we are taking early steps to educate people as to what they need to do before the person turns 18. That alongside, as honourable members have commented, the toolkit, which provides practical guidance in terms of how to access the legal process and how to navigate through it. I've mentioned also, the mailing that we've agreed with TISA, but also one of the second asks was making people aware of how to find these lost funds. And so we are doing more work to provide information, and people can use the Find My Child Trust Fund service on gov.uk, and we can continue to do more to raise awareness of that, so that people are, of course.
I think it's a good idea that the providers are prepared to write out and provide additional information, and I personally welcome that. It's not going to solve the problem, but what I would say to the Minister is, does he agree with me that it's no good that just being a one-off? This is going to have to be something that's done on a regular basis, because as young people become more and more mature and move towards the age of 18.
The honourable friend, the Shadow Minister, preempts. This is a regular communication strategy. TISA will continue to notify those who are heading towards maturity what they need to do to actually access once they turn 18. Alongside that, I've been working with the Department for Work and Pensions on accessing their client bank, and so we have agreed that they to be able to contact with DWP the cohort of parents and carers who receive PIP payments, who may lack mental capacity to access their child trust fund. And we have an agreement in principle that we were doing a mailing, and this will not just be a one-off, this will be a constant mailing, so that as people in those cohorts, which we think is particularly relevant to the child trust fund and difficulties of access, became aware in advance of what they need to do. Because one of the big messages from the consultation was our lack of understanding and our lack of knowledge of the steps until it was too late. So I appreciate that members have said, give them the money. But equally, and I get that, and as I've mentioned at the very start, for the vast majority of parents, they act in the very best interest. And I'm not a parent, so I cannot possibly understand the role of a parent having to juggle all of the demands of everyday life and having a child that needs additional support. And I accept that my knowledge is very limited, but it does weigh very heavily on me that I want to ensure that just one parent not acting in the best interest and accessing those funds inappropriately weighs very heavily on me. So I accept all the points of proportionality, and I'm very happy to have a conversation as to where that line is drawn on risk. But broadly speaking, where I'm coming from is improving education, improving access, improving knowledge. But I'm not going to, and I cannot in all conscience say I'm going to throw open the accounts and give unfettered access without some checks and safeguards to ensure that a very small minority do not have the ability to abuse a young adult. But I will commit to following through with colleagues at DWP on the scheme they use to see if there's anything we can do to copy it or piggyback it to make the system more accessible. Thank you, Ms. Howard.
Sir Jeremy Quinn to wind up.
Thank you, Ms. Elliott. Look, I'm grateful for the Minister's candour with us today. We've heard what he's had to say. I like the right honourable the member for Kingston upon Thames. I was keen to work with the Minister, and I know he has put in train changes to seek to improve the situation. I'm pleased to hear what he said about the mailing, and certainly we will, I'm sure, work with him to see how it can be improved. but despite his absolutely genuine intent, which I know is genuine, and that his genuine worries about making certain there is a scheme that is safe for all, there is still a concern here, and this is about proportionality, that thousands of young people may miss out because of the Minister's genuine concern about what could be a very, very small number indeed. I come back to the point on DWP appointee scheme. If fraud is at work, and that's always a risk in any form of the government distributing money or giving access to money, if fraud is at work, there is far, far bigger fish to fry here than the Child Trust Fund. And trying to avoid that tiny risk does prevent access for many thousands of people. And I think we should be able to find a more effective and secure, yet secure way through it. So I would urge him to keep reviewing it. I'm very pleased to hear what he says about talking to DWP about that process. I understand the point he makes on primary legislation. But ultimately, if it requires primary legislation to ensure that we can right a wrong and get fairness, it would not, I'm sure, be a controversial bit of legislation. And what on earth are we here for? So I look forward to ongoing discussions with the Minister and finding a solution that absolutely works for all these disabled young people and their families.
Question is that this House has considered Child Trust Fund access for people seeking to manage the finances of others. As many of that opinion say aye. Aye. To the contrary, no. I think the ayes have it. The ayes have it. Order, order. The sitting stands adjourned. Excellent.
Thank you very much, Chair.
The proceeding has ended. 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 The proceeding has ended.